Court of Appeal don evict Lagos Tenant after 19 years when e no pay rent. Islam frivolous appeal. E con refer lawyer for disciplinary action. Welcome to Synok Media. We wan thank country people when e dey view our channel. Abeg, if you never subscribe, make you do so now. Make you put on your notification bell. E go ring once we drop update. Make you like, comment and share our videos. Country people, the Court of Appeal for Lagos don dismiss one appeal for one long-standing tenancy dispute. E con order the immediate eviction of the appellant from a property when e dey located at number 55 Adeniyi Jones Avenue for Ikeja, Lagos. The judgment, when they deliver on July 9, 2025 by Justices Frederick Oziakpono Oho, Olabode Abimbola Adegboyingbe, and Nnamdi Okwudingba for appeal number CA/LAG/840/2017, con affirm a 2017 decision of the Lagos High Court. E con impose a 5 million naira fine cost against the appellant, say e file wetin the court describe as frivolous and abusive appeal. The dispute start for 2009 when the property owner, Mrs. Antonia Olufunke Carrio, e con seek to recover possession of her 16-room office accommodation. The appellant, wey im tenancy start for 1988, e con overstay after the lease elapsed for 1998. E con dey claim instead say a fresh 10-year tenancy agreement dey in place based on a 2006 letter from Mrs. Karu former solicitor Chief Kunle Oyewo. Mrs. Karu con disclaim the letter, say e no dey authorized. For April 26, 2017 judgment, the Lagos High Court con hold say no valid tenancy agreement exists. E con order the appellant make dem vacate the premises. The court con further award 500,000 naira per annum as owed over rent from March 2007 and 250,000 naira for litigation cost. Challenging the decision of the court, the appellant con argue say the High Court lack jurisdiction due to an alleged arbitration clause for the disputed agreement. However, the Court of Appeal con dismiss this argument. E say no tenancy agreement dey when they tender as evidence. E con so hold say the appellant e don waive any right to arbitration as e participate for the full trial without applying for a stay of proceedings under Section 5 of the Arbitration and Conciliation Act 1990. Justice Adegboyingbe, when they deliver the lead judgment, e con describe the appeal as a clear abuse of court process. E con note say the alleged 10-year tenancy, if e exist, e for don expire by February 2017. E con make the appeal moot. The court con strongly criticize both the appellant and their lawyer, John Okoriko Esquire. He say because they attempt to use the judicial process to unjustly retain possession of the property for 19 years without consent. Country people, this matter, so as part of the ruling, the court con order the immediate eviction of the appellant from the property. The court con also put restraint on any interference with court bailiffs when e go execute the eviction. The court con also say They go pay 5 million naira as cost to Mrs. Cario. The court can also forward the case records to the President of the Court of Appeal for possible disciplinary action against Mr. Okoriko under the Legal Practitioners Disciplinary Committee Rules 2020. Justice Dingba, when he dey concur with the judgment, he come note say the case exemplify misuse of litigation rights. He come dey cite Saraki versus Kotoye 1992 as authority. The panel come agree say the prolonged abuse of court processes e dey undermine confidence for the legal system. As they come dey react to the ruling, C.I. Okolo, lawyer to Mrs. Cario, come tok. He say dis ruling e dey reaffirm the judiciary commitment to protect property rights and to curb abuse of the legal process. He say dis one dey send a strong message against frivolous litigation when e dey intended to frustrate rightful owners of properties. Country people, dis case so na landmark case how a tenant come use ogboju take stay somebody property for 19 years and he come use the court as the template to execute an illegal act. And also he come get lawyer when e dey help am dey do this illegality. That one go fit be the reason why the Court of Appeal e dey take disciplinary action against the lawyer to the appellant, because they believe say the lawyer know say na frivolous appeal na dem dey make to unjustly occupy somebody property after 19 years and dem not pay rent. If you look at that matter under the morality clause, na man's inhumanity to man, na wickedness of the highest order, and the court don frown at this situation. The company itself, when e do this thing, people dey of the opinion say they're supposed to blacklist am, that even Mrs. Cario, the owner of the property, supposed to even file another suit to claim damages for the torture when the appellant don make am pass through for all these years when they dey drag am dey go court up and down. Country people, how una see this matter